Is a best and final offer truly best and final? Welcome back to the channel. I'm your host, Ken Johnson. Today we're doing something a little different. We're in a different format. So this is a virtual environment, obviously. This is not my kitchen. This is just a trick us mediators use for making people feel comfortable. And so being somebody's kitchen is very intimate and allows people to feel safe. That's the reason why I got this background screen. So today we're talking about mediation, and this is what my office looks like, my virtual office on Zoom. So I am recording this through Zoom, so you see everything just as my clients see it. And so what we're talking today is about mediations and best and final offers, and whether or not it's ethical, and if it is ethical, how do we get past what could be a roadblock. So depending upon where you're at in the world, this may count as a continuous mediator education credit. So if your jurisdiction and certifying authority allows it, this should count for 1 hour of mediator education credits in ethics. And so that's what we're going to be talking about today, is whether or not it's ethical, and also how we break it, if we should break it. The first question I think we need to go through is, what is mediation, and what am I, and why all this is going on? So who am I? If you're not used to my channel, I am Ken Johnson. I am a YouTube creator. I normally do stuff on YouTube that is not really mediation stuff. So this is not a mediation channel. I call it a life channel. However, for the purposes of this video, if you're using this for mediator credits, I am a Florida certified mediator in the fields of county, family, and circuit civil law. Okay? And I'm also a restorative justice facilitator. In the state of Florida, we use a thing called facilitated mediation. There's different types of mediation styles out there. And Florida has a rule that we have to use facilitated mediation. That's what gets certified here by the Florida Supreme Court's Dispute Resolution Center. So that's who I have my certifications through. I also have certifications through the United States Department of Agriculture, and I am also qualified to serve over in Hawaii for eviction mediation. So I've got multiple certifications and acknowledgments and recognitions. So what is a facilitated mediation process, and what's my role in everything? Think of it as a negotiation process. So mediations that are facilitated mediations, you have a neutral third party or a disinterested third party. That means that I cannot know the people. Now, there are some exceptions, like if I'm dealing, in court cases, I'm going to know some of the attorneys just by doing previous mediations. But it means that really and truly, I don't go out and have drinks with them or go to their family events or anything of that nature. I don't go to their office Christmas parties, anything of that nature. It is that we've just professionally known each other, but that it goes no further. But generally speaking, I'm not supposed to know the parties, and I am not supposed to make any decisions for the parties. Basically, I ask questions. If I want to point somebody to a certain direction, my instructions through my certifying authority is that I'm supposed to ask questions that leads them there. So instead of saying, consider all these things, I have to do something like this. Have you considered X, Y, Z? My job is to challenge points of view. In my restorative justice practice, I talk a lot about perceptions and viewpoints and vantages, and that carries over into my mediation practice as well. That we all have a certain viewpoint, we all have a certain bias, we all have these things that cloud our ability to see things differently. And sometimes just changing your lenses just a little bit. Howard Zehr, he's a restorative justice author. I also am an author, but I refer to him a lot in my writings. Howard, he has a book called Changing Lenses, and he talks about that. Of course, from a restorative justice perspective, non-mediation perspective. But what I'll do is that I will challenge points of view, play devil's advocate, and I will then try to get people to see other ways of viewing things in the hopes that might lead them to agreement. The purpose usually in a mediation is an agreement. So that's what the authority that sends people my way for clients, they want an agreement. Why would parties be here? As I said before, usually there is a authority, not me, but somebody, some organization, something out there that is bringing parties to me to mediate. And so a lot of my work is either going to be dealing with what we call NGO or non-governmental organizations. NGOs are basically nonprofits. They can be for-profits sometimes, but usually it's a nonprofit, and they're a private company, either for-profit or nonprofit, that the government has entrusted and authorized to handle a specific function. So, for instance, in some counties here in Northwest Florida, there's nonprofits that for large animals, like horses that are being mistreated, that there's nonprofits that they actually have authority to take animals off of property that have been mistreated and levy criminal charges, things of that nature, against an offending person. The same is true for mediations. So, for instance, after COVID, a lot of people in the state of Hawaii, they were getting evicted after COVID. And so because the governor of Hawaii did what the U.S. government asked of them, the U.S. government sent money that was funneled to nonprofit mediation firms that took on cases for their county, and they handled all the eviction cases through mediation before it went to trial. In Florida, normally what will happen is that each circuit has an ADR coordinator, and that ADR stands for Alternative Dispute Resolution. And so that ADR coordinator will be told by the judge, that normally it's the chief judge, will say, I want no county cases going before a judge unless they've been mediated first. So that means that they will assign mediators to the cases and we will mediate it out. The same is true for like family law cases. Family law cases, they will say, okay, before we handle this paternity suit or we handle this divorce or anything, you need to go to a mediator. And so then you either have to find one or you go through the ADR office and they'll assign you one. Then there's other different government organizations that they have their own type of ADR process. For instance, USDA, they have a ADR. So if you ever have a issue with anything that the USDA is doing and you're getting benefits from the USDA, or you applied and were denied, at any point in the process of appeals, you can actually go and have a mediator be assigned and take it to mediation. In the state of Florida, another program that I'm affiliated with, if you have an insurance claim, let's say a hurricane blew off your roof, you had a plumbing issue, and it flooded out your home. It wasn't due to a natural flood, it was due to a plumbing issue. Any host of issues like that, the Florida Department of Financial Services Insurance Division has a mediation team, and I get assigned those cases. Well, I do other things, but that's a general run through of why and how you would be in front of me. It means that you have went to either one of these organizations or you're in court, and so now you're in front of a mediator. So let's talk about confidentiality, and this is very important. With confidentiality, in the state of Florida, I have what is known as judicial confidentiality. It is the highest level confidentiality that the state of Florida affords a person. That means that unless I am required or permitted by law to report something, then a judge cannot compel me to testify what went on in the mediation. And I cannot say what went on in the mediation. Now, there is a board that they can call me in if there's ever any type of ethics complaint. That board, that's a part of the Supreme Court of Florida, their Dispute Resolution Center, that board is the only entity in the state of Florida that can compel me to break my confidentiality. And if I ever have to break my confidentiality on a case and I am found to be not in the wrong, I am allowed to then go after the parties that filed a complaint against me and seek legal remedies for making me have to not only defend myself, but also break that vow of confidentiality. And so we take that very strongly in the state of Florida, that even though we have the most liberal public records law in the world, so if you put anything on public record, or you write a letter and there's you write a letter to some type of government agency and you put your phone number and address and email, that's all public record usually. So this is kind of interesting that I do get a very high level of confidentiality that extends to in cases or pre-mediation discussions that I have. And so that means that it's a safe space that we can talk. And in Zoom, I can actually do what we used to call in the old terms caucuses. Now we call them breakout rooms. And I can create rooms, put people in rooms. We can talk privately, and unless they give me authority to speak, I cannot break that confidentiality. The only time I can say something that without permission to give that information is if it is something that I'm required or permitted by law to report. Requirements in Florida are very limited. So you got a disadvantaged person, a child, an elderly person, a mentally handicapped person, a disabled person. that's being abused, neglected, or taken advantage of, I can speak about that. Some type of criminal activity that is nefarious, I am allowed to report if I so choose, but I do not have to report. So that means that if somebody comes to me and they say, I'm going to kill somebody after this mediation. Back when I first got certified, I could not say anything to the cops. It was against the law. And now they've changed that to where I can say something if I wish to. I could have always remained silent, but that would just be unconscionable. And so since it's unconscionable, I have an ethical duty as a mediator to report, at least for me, because it goes against my ethics. And I just can't, I could never live with myself if I didn't. And for that reason, since it'd be a nefarious criminal activity, I could report it. Let's do a rundown of how the mediation process happens. Simply put, it goes in stages. So I do an opening statement, which I normally say who I am, who I'm with. I explain what a mediation is. That's a confidential, facilitated negotiation process. I then give that disclaimer. Everything we say in mediation is confidential, except where I'm required or permitted by law to report, or if we reach a settlement agreement today. Because if you have a memorialized mediation settlement agreement, that does not withstand the confidentiality. It's one of the few things that doesn't withstand the confidentiality. And so you have to let them know that if you reach a settlement agreement, then that settlement agreement is not confidential. Then from there, the process will go that we do opening statements. Generally speaking, opening statement is saying why we're here, what happened, how much money is being required, or what type of remedy is being required. Usually it's money. If you've ever read anything about any of my writings, I normally talk about Lohman's cabbage model of conflict. And I explain that money is so easy to articulate that there may be other conflicts out that cause the money, but people normally do not know about those conflicts until they're in mediation. We can resolve those conflicts. And that's some of the counseling aspect that I didn't talk about earlier, but sometimes I have to play camp counselor. In fact, a lot of my job is almost playing camp counselor, even though I'm not a certified counselor. That is part of what we do, is to allow people to have their say and feel that they had their day in court, whatever that may be, so that they can hopefully arrive at justice, or whatever they consider to be fair, be made as whole, anything of that nature, because everybody has different aspects and different thoughts as to what they're expecting. And then, so one side will have their opening statement, another side will have their opening statement. I ask the parties never to interrupt each other. Then I like to keep people into what I call general caucus, or the main room. And the reason why I like to do that is that I think if people can talk to each other as people, you're generally speaking better off. Now, there are exceptions. Let's say that there is a power imbalance issue, domestic violence issue. These cases require special attention and special care. And so in those cases, I may actually start out a mediation in separate breakout rooms where I give the same opening statement to both parties and then ask why we're here, and then go through the process that way. So you do have to realize sometimes it is not best to have the parties together. So it may actually do more harm than good. So in those cases, the mediator may have it broke out in separate parties. But generally speaking, I like to keep the parties together as much as possible, so long as that there's not any compelling reason not to. Now, if they ever ask to be in separate rooms, we can definitely, accommodate that, and I do separate rooms, and then I'll come in, talk with them, and from there, I'll usually have a statement at the very end before I leave, and it'll be a question, something along the lines of, is there anything that we discussed that I cannot share with the other party? Now, why did I ask that? Simply put, I can't say anything that went on in that discussion unless I get permission. And so if they say there's nothing that we talk about that you can't share with them, I have full authority to go and share whatever I need to share to reach that agreement. If they say you can only talk about XYZ, I only have XYZ's authority, nothing else. So you have to be very careful. If you have no authority whatsoever and you did not get that authority, you cannot discuss. So it may be, wait a minute, I need to clarify something. I just realized I wrote something, make some excuse or whatever. Say, hey, look, I didn't write something down, or I didn't get something I needed. I need to go back and then get that authority before you start speaking. If you don't do that, it's a breach of ethics. And so you need to understand that if you're a mediator, that at least in the state of Florida, your laws may vary. You've got to go by your laws, but I'm talking about Florida laws. You need to make sure that you have that authority. Usually, I go back and forth with numbers or issues until we finally reach an agreement, and then we have a settlement agreement, hopefully. That is not the only outcome that can happen. The other outcome is we have a thing called an impasse, or no agreement. All right? So the impasse just basically means that there was no agreement, no consensus. At any point, any party can do an impasse. And so I may do a video on trying to break an impasse in the future. If you're interested in that, please let me know in the comments. But there's some ethics involved with that, just as there's ethics about what we're talking today about with best and final offers. So that's something to understand. A lot of times when the figures are being discussed, especially if it's like an insurance case or a commercial case, where maybe payments have already been made out, maybe there's withholdings, anything of that nature, there's two figures that can be tossed about. One is gross and one is net, or what we call new money. So gross just means that if it's a $30,000 case, then $30,000 includes any monies that you receive in addition to what you've already received, and anything that was held back due to, like, recoverable depreciation or something like that. Recoverable depreciation is something that a lot of insurance companies do, that says that until you actually fix the item, we will not give you back this depreciation money. And so in mediation, they may say, okay, we'll give you recoverable depreciation plus, XYZ. So we're going to give you $15,000 in new money. If they'd already gave you $15,000 before, it's a $30,000 gross or $15,000 new money. So you got to first realize, what are you talking about when you're mediating? And so I'll ask, are we talking gross or are we talking new money? I like new money. I hate to deal with gross, because then I have to do unnecessary figuring. Okay? They all know a gross figure, but they also know where they want to be at, where they think they need to be at. That's what we call black swan. A black swan is something that you don't want somebody knowing It don't have to be your bottom line. It could be some other aspect you don't want a party knowing about. But I consider it to be a black swan for your bottom line as well. But that's a known black swan. You should come into a mediation with a bottom line that you know, okay, this is where I really want to be at. This is about as low as I can go. And so I like to talk new money if possible. It's just easier. It's better to articulate. It's faster in the process if everybody knows what they're getting at. Some people, they prefer gross. They think in terms of gross. That's how they have to report, is in terms of gross. I get it. I understand. So you have to realize, ethically speaking, you need to discuss whether or not you're talking gross or new, because it would be a travesty to spend an hour and a half mediating a case only to find out that one party was thinking gross and one party was thinking new money. And so you just need to make sure you got that hammered out first. What is a best and final, figure? Simply put, a best and final figure is where a person is saying, okay, I'm only going to go down this low. And if you keep on, or if you try to come back with something, we're just going to impasse. It is a tactic that I hate for people to use, but sometimes it is advantageous. It gets to the bottom line. And some people appreciate that and some people do not. And you have to treat it on a case-by-case basis, or as said in the Latin, sum sic. So you just treat it on a case-by-case. Sometimes that is an atomic bomb going off, and sometimes that is a blessing. So let's use insurance. You come back and you say, I need $20,000 new money. Insurance company, they come back and they say, we're going to give $5,000 best and final offer. Okay, that's a big disparity. Now, if the person rejects it, that you bring that $5,000 offer to, the implication of best and final means that if you do not agree to this, we're going to impasse. And so that means that you've got to have a game plan if the mediation fails. Now, there used to be a process in Florida where you could have engineers go out and then you hired an umpire, and the umpire make a decision based off of the engineer reports and do what they call appraisal. They write up all the appraisal amounts and everything, then the umpire make a decision based off of the two professionals from the two sides. A lot of insurance companies are going away from that. I'm not saying it's totally gone. I'm just saying that a lot of them are doing away with that. Some contracts, depending on where you're at, go for arbitration. If you don't know what arbitration is where you have a neutral or disinterested third party that plays the part of a pseudo judge. They're not a magistrate. They're not a judge. They're not a hearing officer. So they're not anybody that's in the judiciary in that capacity. But usually, at least in the state of Florida, they're a attorney or retired judge that has been certified to be an arbitrator, or they can be a panel of 3 mediators that are certified in arbitration. I've always thought that statute to be stupid. I wish that they would just allow it to mediators. I think that we need to have a law changed in Florida stating that you could do county arbitrations if you're a county mediator for at least 5 years, and then if you do county mediations for 5 years and you're already certified as a circuit mediator at the time of getting arbitrator certification, that then you get moved up to circuit. That's what I feel the law should be, but that is not what the law states. For that reason, nobody in the right mind is going to pay for 3 mediators serve on a board usually. So you'll get somebody that's an attorney, and so that's an industry bias that's written into the statutes that I dislike, because we're not supposed to give any type of legal advice, but you find that the Supreme Court gives bias to attorneys, even though the statutes say that there should be no bias to attorneys. So you do see that in this. I think it's wrong, but they're the governing agency, and I can't do anything to go against them, unfortunately, other than state my own opinions here that I think it's ethically wrong. But with that said, you can do arbitrations in some aspects. Arbitrations can be either binding or non-binding. If it's binding, that means that you're really not going to pretty much go to a judge. Usually, if you do, judge is going to stand by the arbitration, generally speaking. If it's non-binding, then it could go before a judge still. It's just something that they reached an agreement on. Usually, the big difference I tell people between a mediator and an arbitrator is that the arbitrator does make decisions and does render opinions, whereas a mediator does not. I will also put out this caveat that there is a type of insurance, and most people are not aware of it. And I think that from a personal perspective, I feel it's unethical, but attorneys have to have assurances when they take cases on contingency that they're not hurting their firm. And so some of them will take out insurance claims or policies on their contingency cases. And this is a big case. This is a big issue nationwide, but especially in Florida, that a lot of these insurance policies on contingency cases do not allow mediations or arbitrations or other ways to handle the dispute other than before a judge. And I think that ties the hands of the attorney, and it actually bars your right to alternative dispute methods that might be more affordable, easier, faster, and better in the long run for the parties involved. I wish that there was a law barring that, but there is not. No state rep that I've talked to, no state senator, no one in the state of Florida seems interested in taking this on. I wish that they would. But I did need to bring this up because that is an impediment to these cases. So sometimes you never get to best and final because the attorney might say, we're at an impasse. They went to mediation. That was it. And they do not want to lose out on that insurance policy. And sometimes their clients don't even know that they're paying for that in the end, that that's part of the cost that they're going to pay if they win. So I think that's important to note, that there could be issues at play where somebody just has to impasse. It's not that they don't want to negotiate. It's the fact that they're wanting to impasse. But if you ever get to the part where you're actually doing a best and final, what I like to do first is to ask the party, is this a hard best and final? If they've been doing this for a long time, then they'll probably laugh or chuckle and they'll say, well, it's not a hard one. Or they may say, yes, I'm very firm. Okay. So if I know that it's not a hard best and final, I know that I've got room to play. that I know that they gave the threat of impassing without really wanting to follow through, that they're still committed to the process and that they're trusting me enough that maybe I can get something done. So we talked about difference between 5,000 and 15,000. Big difference. All right. So I go to the party. Now, one way to break past the best and final is to ignore it. And ignoring it and keep mediating is a dangerous proposition, and it does have ethical concern. By me asking how hard the mediation or how hard they were on the best and final, I pretty much have fulfilled my ethical duty, that I've implied that there is still room, that they're still wishing to mediate, and that this is not a true hard best and final. So in some cases, I'm not saying all cases, but in some cases, just ignoring the best and final and keep mediating is the best approach. It is, you just basically, they say, oh, I know that they're saying a best and final, but if they will do $7,000 instead of $5,000, we'll do, whatever. So they say, all right, $7,000. Then you go to somebody and then they say, well, I know you said your best and final was $5,000, but now they're saying $7,000. All right, that's a big jump. Would you be willing to consider it? And so that's when I do my little tricks. I try to go through all these reasons and things of that nature if I need to. If they say, well, I'll do 5,500. All right, then I may keep going back and forth with both of them saying best and final until I get to a final amount. And then they're in a total agreement. And that best and final was nowhere near what their best and final was. But I asked both parties, were you firm on it? And they said no. And we reached an agreement. So step one is, based off of you getting more information, it may be advantageous to keep mediating. It may sound counterintuitive, but that does work. And that is how I get a lot of mediations completed where I am trying to break a best and final. Number two, I alluded to it originally in step one, but number two is what I call appeal to reason. And so that is where I start asking a series of questions meant to challenge their point of view and their stance as far as where this is going to head them. So I might ask them, what are the options? Or, is doing appraisal an option? Is arbitration an option? Are you going straight to court? Okay, so what are the options? The next, so what are the costs for all this? What are you going to pay out? If you go to appraisal, you got to hire a professional, you got to pay for them. If you go to arbitration, you got to pay for the arbitrator. If you go to court, you got to pay court fees. You got to pay all these other fees that are tied in. You got to pay for a sheriff or a process server to serve the parties. You got to pay for a court stenographer. You got to pay for all these issues. There's filing fees that are attached. There's all sorts of costs that aren't even bringing in the attorneys and their staff and their special witnesses and the special reports and all the other people that maybe you have to get a special engineer. Maybe you need 2 or 3 reports. You need a special plumber. You need a special whatever it is. All that gets added on. And then there's time loss. So not only are you losing time for today in your mediation, but now you got loss of time for the appraisal process if you're doing appraisal. You got time lost for arbitration if you're doing arbitration. If you take it to court, then you're going to have multiple times that you got to meet with your attorney, multiple times that you're going to have to be taking depositions and things of that nature, multiple times that you're going to have to be leaving your job for meeting with all these special people that are going to be called to court as experts for them to do their job. So you got to see all them. And all this time is not recoverable. You're not, because it's building for your court case, that is not recoverable usually. In some cases it may be, but generally speaking, it's not. So you may be 2 years out and you may have clocked in 120 hours or more that you've lost that's not recoverable. Plus all the other issues at play. The next one is money loss. So we talked about time loss, but let's say that you have to lose time from your job. Okay. I used to work for the government. When I worked for the government, I had X number of hours that were holiday time, and then I had X number of hours that I accrued. And if I went past that time, I just lost it. So you may be working without pay, or if you're taking that time off, that is time that you could have used elsewhere. And when I left the government, because of my contract with the government, I got paid for my time that I did not use. And so time is money. And so that is one type of money loss that's unrecoverable. Attorney's fees, a lot of times the attorneys will say, oh, we'll get the insurance company to pay, or we'll get the other party to pay. But that's in their ads, because they want you to do the contingency. But when you're in the office, and you've signed the paperwork afterwards, usually that is the way it works. They want you to sign that paperwork taking them on. Sometimes the better attorneys will tell you up front, but I have been there where they didn't, personally. Then that's when you find out that there are thresholds in play, and that if you do not agree to a certain percentage of the case, the attorney's fees may not be recoverable, and you have to pay those attorney's fees out of pocket. There's also other expert fees. For instance, let's say that you went to this is a case for insurance and you had a public adjuster. Well, you have to pay for the public adjuster, and they can be anywhere from 10 to 20% of the final case. And then you think about the attorneys and what they charge. You expect about a good third for that. I have seen attorneys do 10%. I've seen lower, but a third can be up to what they charge. Then if you got to pay for all the special, people in the case, they have their own fees. You have to pay for copy costs, and I've been charged before by attorneys $3 a page for a copying fee, which is ludicrous in my opinion, but that's what they charged. And so all the mailings, all that stuff that they incurred, that they said that they incurred, they would I had to pay all that. And I felt at the end, I felt more robbed and cheated than anything else, but it was something I had to pay. That's what I agreed to for doing contingency. So that's something that you have to realize, that you got all these different fees, expert fees, time off from work, depots, travel. That's the other thing. If you have to travel, none of that gets recoverable usually in a case. You might can try for it, but generally speaking, it's been my experience. But all cases are on their own merits, and you need to talk with your own attorney. But in my case, it was very difficult to get all that back. Then there's also the loss of usage. It can take 2 years or more for something to go to trial. Your vehicle is destroyed. Okay, you gotta get a new vehicle. Trying to get the money to pay for that new vehicle and to pay for all this stuff. You got 2 years you got to suffer above and beyond. If it is let's look at from the point of the insurance company, because I said I have to be fair and impartial. Okay, they've got to pay for all their staff. They now have to pay for attorneys. They have to pay for depositions. They've got time that it's now on the books, so they got it listed as being a unpaid claim. They've got government sources that they got to account to and respond to. They got money that is not freed up that counts towards their solvency. There's all sorts of issues at play that they have to consider. And so it works both ways. You play both sides, or not play both sides, but you contest both sides' point of view. You're not being one-sided, you're being fair and just and equal as best as possible to all parties at all times. And so that's your ethical duty. But when you're challenging one, you got to challenge the other, or should challenge the other. So that's where you do that. You just have to think, what is the court costs, time, money, and loss of usage for one side, and then do the same thing for the other. And that's what I'm trying to get at. I may point to one side as an example, but you're supposed to do it to both sides when applicable. Another way that we can break the best and final is with what I call the silver bullet. So the silver bullet is a trick that we mediators have when we think that the parties are going to reach an impasse, and we think that we could negotiate it and get it to an agreement. We can suggest a number. So back in the old days, what I would do is write a figure on a piece of paper and slide it over and say, I'm fixing to leave the room, and I want you to consider this figure. This is what, in my professional opinion, I think I can get the other side to agree to. And so let's say that we got a difference between 7,000 and 15,000, or 7,000, 5,000. Okay. It was 15,000 and 5,000 at, or let's say 7,000, 5,500 is what we was at. 7,000, 5,500. I may say, I think that I can get the parties to 6,500. All right. So it's $1,000 more, $500 less on the other. All right. It's not quite in the middle, but it's close. But I think that I could do it. So let's say that I've already tried contesting all lines of thought about time, the money loss as far as, the court costs, all these issues at play, and they seem immovable. What I'll do is right before I leave a Zoom meeting or something other, I'll say, look, there is this thing called a silver bullet. It is a way for us to possibly resolve this conflict. And I think I can get it resolved. And so I've got a figure in my head. I'm going to leave it with you. I'm going to go talk with them right now, do the same thing with them. But I think 6,500. And you don't have to give me an answer now, but if either side rejects this number, we're at an impasse, and that will be done. Okay? So I'll leave. I'll go to the other side, do that. That is the silver bullet. It works sometimes. Sometimes it don't. You have to be very careful with it. It's supposed to be a last-ditch effort. Another trick that you can do is a thing that I like to do, which is to bring all the parties back to caucus. It's not silver bullet, but after the silver bullet, I may say, please stay and let's go back in general caucus. Then I'll do something along the lines of saying, everybody, it seems that we seem to be at a impasse at this point in time. I just wanted to give everybody the opportunity to at least discuss one more time in case there's any information that you two need. Also, if either party be willing to continue discussing this matter now that you're in front of each other, I'm willing to still hear this. Otherwise, we will be at an impasse. About 10% of the time, this trick works. That I'm already saying that we're fixing to reach an impasse, that I'm just getting everybody together in case there's anything that they wish to discuss. Otherwise, we're at an impasse. I've given them the option. And like I said, 10% of the time it works. It is truly my last Hail Mary. It's all the only last trick I've got left. From there, if they say no, then we impasse and that's it. Nothing you can do about it. Impasse is not a loss. Impasse is just as good as if there was agreement. There is no wins or losses in mediation. Not for the mediator. There's just the outcome. It is not our problem. It is not our conflict. We do not own it. The parties own the conflict. You have an ethical responsibility to always have the parties own the conflict. We're to empower them. We're to challenge them. But we are not to take on the conflict as our own. So this is one of those things that we honor it. We say, okay, we're at an impasse. Thank you for coming. Have a great day. And that's it. And then I write it down, my mediator disposition or mediator report, whatever the agency wants to call it, that we reached the impasse, how much time, do my billable hours, all that stuff. If they continue to negotiate, I continue to mediate. So let's say, I said 6,500. One of them says, if you'll do $6,250, I'll do it. Okay, maybe that's what it was. Maybe my figure was off. I've had crazy numbers. I won $100,000 and sell $15,000. I've had. We're not supposed to talk about brackets in mediation, but brackets where you got a low number and a high number, and where that space is your brackets. I've had crazy brackets before, and it gets settled for amounts I would never have thought in a million years that it would settle for. We don't get all the story. We don't know all the sides. We don't know everything. We're not God. We're just being presented a side of the story by one side and another side of the story by another. I tell my wife that the truth is a three-edged sword. That third edge is the side that we don't know, the truth. And so I always try to find that third edge in mediation. That's very difficult. It's kind of like I'll sometimes tell children there's three sides to every coin, because you got that edge that nobody ever thinks about. And so, a lot of Christians got upset with the Sacagawea coin because it was one of the first coins in America not to say "In God We Trust," at least one of the first coins in contemporary history to not say "In God We Trust." But it did. It just wasn't on a side that they recognized. It was on the edge. And that's something I was telling somebody before. It's like, it is. It's just on the edge. It's that third side. People don't think there is a third side to a coin, but there is. Same thing with mediation. I try to get to that third side, but sometimes I can't. And that figure is not necessarily the whole truth, is just an agreement. And so if they wish to agree, I'm good with it. If they don't, I'm still good with it, because it's not my conflict. So let's talk about, is all this ethical? Because that is the whole point of getting ethics credit for this. And we talked a lot about ethics already. Mentioned ethics multiple times. If something's unconscionable, you can't do it, because of ethics. The ethics of confidentiality. We talked about a bunch of different ethical aspects, and in there, I made sure to explain that I asked first, how firm are you on this? Best and final. If they say they're pretty firm on this, I may follow up and say, is there any circumstance, if they happen to come back with a number that's different, is there any circumstance you would continue to still mediate? Would you still be willing to entertain any other offers, or are you hard and set? Because some people are hard and set, and you can't force somebody to stay in a mediation once they've asked for an impasse. But if they haven't asked for the impasse and they're just threatening, but they're not actually asking for the impasse, then you can, so long as you do it with the understanding that you're walking a very tight rope. You've got to be careful. You've got to be aware that they own the conflict, not you, and you're not putting your personal wishes in front of their wishes, because their wishes matter. They're the ones that have to sign off on the agreement. They're the ones that have to live with the agreement, not the mediator. It is not our problem. So therefore, I ask, are you okay with possibly, if they come up with another number, would you trust me enough to keep trying to get this done? I know you're wanting to get at best and final, but are you hard and set on it? If they say that they're not that hard and set on it, they're just trying to get to a cut and chase, that they don't want to waste time, okay, it is ethical. If they say no, then you've got to honor it. It is not a loss. It is not a bad tick on you as a mediator. It is nothing like that. It is a choice, and they made a choice, and we have to honor it. So I am not saying to break the best and final if they're totally against it. All right? I am just saying that, after you have tried everything, if they say I'm firm on it, and so I may follow up and say, have you thought about the costs? Have you thought about time? Have you made all these decisions? I may challenge. I can challenge. I can challenge points of view to change perceptions if I think it would be advantageous. And I have to do that in questions. So I'll ask, have you thought about time? Where are you going? What's the figure you expect this case to cost you in the long run? You've done a cost benefits analysis. Is it really worth it to impasse? Are you sure about that? Because when I go back and if they say no, we're gone. And like with the Department of Financial Services, you only get one bite at the apple. So some of these times they're only allowed one opportunity to mediate. So are you good with that? That this is your one time? Are you good saying that you're ready to impasse? So I can challenge, but once I've done every challenging thing that I can do, once I've verified that they fully understand the ramifications of what they're wanting to do. If I tried to break that impasse, that's unethical, and you cannot do that. Now, I may put them back in joint caucus and say, I want to thank y'all. If there's anything that you wish to discuss at this time before we impasse, you're more than free to do that. I do not bring up any figures or whatever. It is in the gray area because one of them could still come up with, would you please consider, they could appeal, but I'll sometimes ask, will it be okay if we go back to general caucus just in case one party has a question or needs information or something. And if they say yes, fine. If they say no, that they want to leave, they can leave. I cannot hold them at that point in time. So I've had some say no is best and final, and I'm done. They left. I can't do anything. They mediated. They did their part. And so I'll tell everyone, they say, well, they didn't stay. I wanted to ask them another question. I want to ask, well, I'm sorry, they left. It was impasse. I told you, they gave you a best and final, and you said no. So you can contact them with any questions you wish to, but as far as the mediation is now over. So you have to hold a line. The only thing that we own is the process as mediators. We do not own the conflict. And so that means that we have to be fair, we have to be unbiased. And whether you like it, dislike it, whatever, it doesn't matter. Thank you for watching. I hope you've enjoyed this video. If you're using it for continuous mediator education credits, please make sure with your certifying authority before you use this video that does qualify. There are no certificates or anything of that nature issued by me. So if you're needing that and they require that, you will not get one from me. If your state, like the state of Florida, at this time, I'm doing this in May of 2024. So watching a presentation is considered to be a CME. So you do not need a certification. You just have to give the title and where you watched it at and how long. But it is 1 hour of CME credits. But thank you for watching. And if you're not a mediator, or you find yourself in need of a mediator and you're in the state of Florida, you can look me up. My name is Ken Johnson. Again, I am certified for county, family, and circuit mediations. And my email will be listed down right here to where you can email me. If you have any questions about what mediation is or anything of that nature, you can put them in the comments. Also, I'll have in the description below a interview I did with Courtroom 5, where I explain mediation. If you have any questions about restorative justice, you can also ask them in the questions below, and I will answer that. Also, there's a video that I'll link down below, Courtroom 5, where I did a interview about restorative justice. So you're able to use those two for references. If your state or your governing agency requires that you do discussion. Depending upon how it's written, placing a comment down below and answering or commenting to somebody else's comment will generally count as classroom discussion online. So we don't have that requirement in the state of Florida, but if your state does have that requirement, you can ask a question and then comment, and somebody responding to your comment as well as my response to your comment can count sometimes as an interactive classroom discussion online. So I do answer all my comments. So I may, if you say good video, I may give you a thumbs up and that's my reply, or I may say thank you or something other. But if you have a legitimate question about mediation, something that I said about this video that dealing with ethics, impasse, any of the terms, anything of that nature, I do answer all my comments and I will answer. All right. With that, thank you for watching. Have a great day and goodbye.